You are recording now.
We have Liv on. Hi, Liv.
Hi, Noelle.
How are you? Good, good.
My dad should be joining too.
We're just going to let everybody know as you're coming in, and we'll make an announcement that this is being recorded. So just so you know.
No problem. I will mute myself.
Manya, I was teasing with the ladies. Why did you tell me we're going live? That's too much pressure. No, just teasing.
We like to put you on the spot.
Yes, I've had many occasions where I've been put on the spot. So, but it's all good. It's all for good cause.
I'm sure. How's your family doing, Shadi? Everyone's good?
Yeah, everyone's good. Everything status quo, thank goodness. Yeah, things are good. Things are good. No complaints. How about you?
Good. Everyone's
Yeah,
good.
kiddos are in school or at home?
Both.
Both. I give you a lot of credit. When mine were at home, I was like, oh Lord, I was like, save me.
It's a lot, but hopefully one day we'll go back to normal.
Yeah, soon.
That'd be
So mine are
nice.
back, so I'm very thankful for that. So
Good.
I'm excited because there's going to be a lot of movement in the market, I think, as a result of some of this stuff. So that'll be good for you guys. And I think it's awesome you guys are putting this together for your clients. I mean, this is amazing. You're going above and beyond for them, and that speaks volumes. So kudos to you guys.
It's important info that a lot of people had questions about, so it's
Yes,
good to
yes.
get the info out there.
Yeah, most people just don't know. They're just not educated. So.
Hello
No,
for us
exactly.
that's joining. I see Anita and Herb. Nice to see you guys.
And Helen. Hi, Helen.
Hi. There's Mr. Tronston too. We got two generations.
Hi guys.
Just so everybody knows, we are recording as you jump on, and we're streaming this live on our Facebook pages as well. So we're going to start in a few minutes, but just letting everybody know ahead of time.
And I think we had about 36 people register, so maybe right
We're going
around
to give
12.
it a few minutes for sure before we start.
Yeah. Hi, Carol. It's Andrea. Just waiting for a few more people and a couple more minutes. Thank you everyone for being muted too. Make sure to type in the chat if you have any questions or anything as we go.
I just changed my view and I'm trying to figure out how to fix that. There we go. Much better.
Couple more minutes.
And Manya, are you doing the introduction again?
Yes.
Okay.
We'll start right at 12 o'clock. So I know everybody's probably has a busy day. Are you working mainly from home or you're going into the office?
Nope, the office. It's just easier for me when you're dealing with planning documents. Oftentimes I find we're so much more effective when we could print the documents, review them. And so, yeah, it's just easier to, I've pretty much been coming into the office. We have such a small boutique office. There's not huge, interaction. So it's nice.
Got it.
Yeah.
Okay, it is 12 o'clock. Let's get started. Since this is being recorded, people can, watch it at a later time as well. So welcome everybody to our Prop 19 class today and taking time out of your day to become more educated. My name is Manya Persekian with the Nest SoCal group at Keller Williams Realty. And for the next 30 minutes, our intention is to educate you all about Prop 19. We were getting so many questions regarding Prop 19, so we reached out to our trusted attorney partner, Shadi Schaefer, with Asset Protection and Elder Law Center. They specialize in estate planning, probate, trust asset protection, life insurance, and much more. So they are the experts. And Shadi is here today to inform us, educate us, and we really appreciate you taking time out of your insane, crazy schedule to be here with us today. So we don't have too much time. We're going to be here from 12 to 12:30. If you can just save your questions towards the end in the chat, that would be great. And we'll try to answer all of your questions. But Shadi, thank you and welcome.
Thank you so much, Manya. I appreciate it. Thank you guys to the Nest SoCal group for putting this on for your clients. It just shows that you guys are going above and beyond for your clients and not just focused on their real estate transactions. So huge kudos to your entire team for putting this on. I do first want to explain, I'm by no means an expert, but I have been doing estate planning now for 19 years and my firm's been together for about 16, 17 years now. And Prop 19 has been, for me personally, it's been the first time in my professional practice where I've been really taken back. And I would have to say, other than the bar, this was the most challenging time of my professional practice. The challenge being is that it's a new law. It's completely changing the face of what was, or what is currently Prop 13. Okay, and that's the basically the property tax credits that parents can pass on to their children, not only for primary residences, but also for rental properties. And the biggest challenge to Prop 19 is one, the lack of understanding of what the law or the proposition is that has basically gone into effect, or that's going into effect officially February 16th of this month, but also the time frame that we as a community, as Californians, had to basically take any action. And so for us trust attorneys, attorneys and CPAs in general, it has been, if I'm being brutally honest, it's been slightly a bit of a nightmare. For me, I'm a very conservative trust attorney, and I don't like to move quickly into planning for clients when there's huge effects to that plan. So one of the things I just want to share with everyone listening is that there's different approaches to responding to Prop 19, but there's always ramifications to certain transactions. So I just want to be clear that I know the timing of this, while it's wonderful that we're educating you, one of my biggest concerns when I was talking to the Nest SoCal group was, well, there's not a lot of time. We're going to educate, your clients, family, friends, your database. But unfortunately, I'm a little bit worried we're going to educate them, but not give them enough time to act. There's still a little bit of time. And I do want to start by saying this to keep it very simple. If you're listening and you're going, does this affect me? And how do I know that? Let me just start by sharing that generally speaking, this proposition is going to affect those individuals who purchased properties many years ago. Now, of course, there's exceptions, but again, generally speaking, this might be a perfect example of how this can affect a family is, mom and dad purchased their property in California in the 70s, and they purchased it for around $300,000. And today the property is over $2 million. That's a perfect example of how it's going to affect someone. So for example, someone like me or my parents just purchased their family residence. They've had houses they've bought and sold and moved. And, they just bought a property about 2 years ago. And so is it going to affect them? No, because they bought their property at about $600,000 and today the property's worth about $650,000. So it's not a huge issue for them whatsoever. Of course, the next argument could be, well, what if they live another 30 years and then that property is $2 million? Yes, of course, it could affect us in that regard. So I just want to kind of explain that this is really for people that have, when you're looking at your tax bill and the assessor's value is, let's say, $200,000 or $300,000, and yet you're sitting in a community like Corona Del Mar or Newport, and the property is now worth 2.5 or 3 million. Someone like that, or families like that, they definitely need to move quickly to plan. That is for the primary residence. So let me sort of take a step back and explain. So currently today under Prop 13, which was the credit we all had, and we're, sometimes you don't know what you have till it's gone. That's kind of what's happened, right? We all had these credits and didn't realize the benefits of what we had. So basically, to keep it simple, currently in the pre-Prop 19 rules under Prop 13 was that I, as a parent, could transfer my property to my children, my primary residence. It could be worth 10 million. And my children would be able to take that property with the same low property tax basis that I had or my husband and I had and that we were paying. Okay. So that was a huge thing. That was a huge benefit to children. And it didn't matter if the kids lived in the property or not. If my siblings and I or my children acquired my property and they didn't want to live in it, they could rent it out and they would still have that low property tax basis. Okay. Now in Prop 19, what's happening is parents can, basically there's limitations to that. Now, only if a child's going to live in the property can they get a property tax credit, the same property tax basis, and there's a limit to that. So it's a two-pronged requirement. If a parent's going to die or transfer the property now post Prop 19, the child will only get the property tax basis if the child lives in the property. Okay, so that's one of the biggest things that's gone away, and that's a huge impact, right? Most children aren't necessarily going to go move in the property and live there. The other thing is there's a limit. So the limit is nothing over $1 million of the assessed value. So basically, if I acquire a property from my parents, their primary residence, and I decide to move into it, but they bought it for $300,000, and the property today is worth $2 million. I'm trying to do this out loud really quick. I'm going to pay the difference of anything over that 1.3. Okay. So now I'm paying the low property tax basis of my mom and dad. Okay. Of anything up to 1.3 million, I'm paying at the low property tax basis. And then that difference, the 700,000 is going to be increased. Okay. So now my property tax bill is going to be different. So that's the biggest distinction between primary residence of parents and passing it now after Prop 19. Okay, so let's talk about Prop 19 passed. My apologies. Prop 19 passed. So the question is, it passed. When does it go into effect? Okay, everybody keeps calling me and they keep talking about February 16th. Yes, February 16th, this proposition now goes into effect. You try to do something on the 17th and 18th, you're out of luck. It's not happening. But here's the thing. You know how you purchase properties and escrow closes? There's a whole time frame of where the paperwork has to be prepared, deeds have to be signed. So the problem here is, I don't want you to think in your head, oh, I've got till February 16th. Really, right now, when clients are calling me today, I'm like, look, we're kind of done. I don't feel comfortable as an attorney to take legal fees if I don't feel, depending on the plan we're doing, that we can execute this, within the time frame. And basically for the attorneys out there, we're all saying that the true hard deadline is February 11th. Why? If you notice on the calendar, February 12th and the 15th is a holiday. The assessor's offices are closed. So if you think about it, there is no 16th. It is the 16th and it's too late. So really, for all intents and purposes, if you're going to do any Prop 19 planning, you really need to get the plans in effect, the deed signed and filed before the 11th. Okay. So there's a lot of talk about what date is going to be the official date of acceptance. Is it the date the assessor files the deed, or is it the date the deed is signed? As attorneys, we're going by the effective sign date of the deed. So let's say my client signed a deed on February 1st and the assessor didn't even process it till March 1st. It should be effective based on the February 1st signing of the deed, transferring, let's say, that property. Whether one option would be outright, hey, I'm mom and dad, I know my daughter wants to live in the property. They have some kind of agreement with the family and they deed it to the daughter outright. That's just a simple example. In that sense, the day mom and dad sign that deed, gifting it to the daughter, February 1st would be the effective date. Okay. So there's a lot of issues going on right now processing. I just did a deed processing. Believe it or not, the assessor's office kicked back the deed and they're like, oh, there's a light print that we can't read. And my office is sitting here looking at the document like, well, we can read it. So we're confused. So you'd be amazed. Deeds do get rejected. So there's some issues here on the time sensitivity of it. And as you can imagine, for estate planning attorneys and any professional or fiduciary that is putting these plans in place right now, there is definitely some hesitation and concern for us as to taking a client's money to do this plan when there's so many other parts to the plan that we don't have control over, which is the processing being done at the assessor's office. As you guys may or may not know right now, a lot of our county and administrative and governmental agencies are backlogged. The courts are backlogged. The assessor's office is backlogged. Prior to Prop 19, I filed an affidavit of death for a client that passed on a property. I filed that in November. I got it back in January. It took 2 months. So there's a processing issue here that is also something to think of. The other credit that I want to mention and discuss is about rental property. Currently, right now, pre-Prop 19, parents have each $1 million credit for rental property, okay, property tax credit. So again, if I have my own home and then I have a rental unit that's, I have tenants in it and it's a rental property, or I might have another single family home that's being rented. If my children, if I wanted to gift that to my children and have them keep the low property tax basis, I would need to do that now if I want to take advantage of that 1 million credit that I have personally, or my husband and I have together of 2 million total. That, folks, is going away completely, effective, I guess you could say effective February 11th, but officially February 16th. So that is the changes that's happening that is making a lot of people out there concerned. As you can imagine, it's going to have a rippling effect because, there are some families who have rental properties and they're being rented and so on. And again, the issue, nothing changes until the parents pass away. And here's the thing, I've talked to some families and they're like, oh, my kids need the money and they don't want to keep the property. And so then there's no issue. I mean, if you don't think that a child is going to truly want to keep the property, then, you definitely don't need to worry about it. So that's something else that I want to mention. But here's the thing. And this is something I want to mention, and there's definitely not always enough time to talk about these things in detail. I don't want anyone to take away my comments here thinking, oh, let me just go deed the property to my child and I don't need to worry about it. There's a lot of different things to consider, okay, because there's tax implications, there's gift tax implications. So there's an analysis that you have to go through with everything. I had a good colleague call and say, I don't care. I'm just going to have my mom gift it to my brother. And I'm like, whoa, slow down. Because here's the other thing too. you have to be mindful that when you're gifting a property to someone, are they married? Do they have creditors? Do they have any liens and judgments against them? Because once they acquire that asset could be, leaned against any judgments and claims and things. So you have to be careful when you're making these transactions. I was talking to a family 2 weeks ago, and they wanted to give it to like one of their children. He's in college, and I was like, wait a minute, is this going to affect any grants or school loans and things the child's getting? Because now this becomes an asset of the child. So there's so many nuances to this that I don't want anyone to think, oh, I'm going to just run out and deed it to my child and yay, I'm done. There's a lot of, things to consider. If these properties are in trusts, so a lot of these people that are calling, they have their properties, as you should, as a Californian, you do not want to own real estate or an LLC that owns real estate and not have a revocable trust plan. That's a probate discussion that we don't have enough time to have today, but I'm telling you, if you're concerned about property taxes and you don't have a simple trust, you got a lot of things going on that you have to definitely consider, because probate in California is huge and very expensive. 2 years on average. The cost is crazy. I won't get into the details. So here's the thing though. There are some parents that have trust. I had a daughter call me just yesterday, LA property. Dad bought it at like between 200 and 300, and today it's worth 2.2 million. That's a huge property tax issue there for them. She's worried that she can't step into the property and acquire it when dad passes because she won't be able to afford the taxes on that. So just to give you guys an idea, and I'm just going to throw some numbers out there. Let's say a parent or parents purchased a property in the 70s for about $300,000. Their property tax might be around $5,600, $6,000. But with this new Prop 19, it's going to change. And it can go, if it's a rental property, it can go up as high as $25,000. So, we're talking about some serious increase in tax payments. It could just be a couple $100 a month currently, but then it'll be $1,000 a month or more, after Prop 19. So one of the things I wanted to mention is a lot of couples have their properties in a revocable trust currently. And the scenario of the daughter was that mom had passed away. Well, as an attorney, I can't just take this property and go, oh, it's in the family trust. Let me just do this. Let me put it in an irrevocable trust. That's one option for Prop 19 planning, other than an outright gift, deeding the property to child or children. But as attorneys, we can't make those decisions quickly. I have to read the trust. I found out with this family that there was a half sibling who is a beneficiary of the trust. So you have to understand, we can't just go, oh yeah, let's help dad and daughter and deed this property, because there's this other sibling that has rights to the property under this trust. Okay. And so if you guys have heard of AB trusts, those are trusts that when the first spouse dies, half the trust becomes irrevocable. So there's limitations there on that. I know people are going to ask about properties under an LLC. Again, there's not enough time for me to get into the discussion about it. And again, I'm not an expert in this area. I've done a lot of research. I would never even do the talk if I didn't feel like I could at least give you guys enough information on it. The issue of LLCs is it comes down to how the property was originally purchased. So there's some considerations there. So I can't really make any blanket statements. If it's acquired automatically, meaning the LLC acquired the property, you actually can gift or transfer shares to a certain amount to children and keep the property tax credits. There are some flexibility when it's owned under an LLC, but you have to go through that analysis. So you have to it takes time to again, go through that analysis. I will share one thing. There are attorneys out there that believe there's going to be other options after Prop 19 for people with LLCs and interests of properties in an LLC. There might be some other planning that you can do. And there's other options for married couples in terms of some things they could do maybe to make this work. Also, as a side note, I feel that within the attorney world, we're all talking about this. We're on Facebook private groups and, listservs, and we feel that there might have to be some give and take, because some think, oh, the Proposition 19 can be deemed unconstitutional, and the Californians didn't understand what they were doing when they voted this in. I will share there's some great parts to Prop 19, and that is the area about individuals over 55 years of age. And so basically, just really quick, just to share, it used to be that if there's an elder in this huge home and all of her kids have moved out and it's just too much house for her, if she sold that house and bought another house, she would kind of lose that low tax basis, right? So now what it's doing, it's allowing our seniors to purchase new properties. There's some exceptions. I won't go through all the details, but that they could purchase a new property and carry that same low tax basis from their original property in an overview. Okay, so there are benefits to Prop 19. There's some benefits in there for the fires recently, the California fires that everyone went through. So there's some good parts to it. I don't want anyone to think that I'm shunning Prop 19, but there's definitely a whole group of people out there that Prop 19 is going to affect. Again, if the kids want to sell the property because they need the money to divide the assets between the children and go get their own properties and live their own lives, then you don't need to really worry about anything. But I will go back to my point on the importance of having your properties in a revocable trust plan. Trust saves all. A will alone in California will not avoid probate. And if I could just share one tidbit, just to give you an example, if I died and I owned a property, and everybody knows I have 3 boys, and my boys are like, who else is supposed to get Shadi's property? She has 3 kids. She's not survived by a husband. Believe it or not, this property, if it was not in a trust, it's going through probate. And the probate fees on the property, I'll give you an example. The property could be worth 1 million market value. I actually could owe the bank 800,000. So let's say it's currently, and I'm in my 40s and I still owe the bank, right? So the equity in the property is like maybe 200. Let's call it 300. My kid, each of my sons would get $100,000 each, right? But here's the thing: if it's not in a trust, the probate fees are based on the market value. It's based on the $1 million. And in California, it's $31,000. $31,000 just to probate that property, go through the courts for my kids to get the equity in it. So that's a huge thing for everyone to keep in mind. And the other thing I'll just throw out there is that's just the minimum cost. So actually that example right there could cost anywhere between $31,000 and as much as $65,000 in all the total fees involved. Administrator fees, filing fees, and so on. So I don't want to get crazy off the Prop 19 subject. And I know there's been some talks, but I think I gave you sort of just a big picture overview of Prop 19. I want to stop there because I know there's people asking questions. And as I mentioned before, some questions have so many aspects to it that I might have to just ask you that we could table it afterwards and we can talk about it. So I'm going to open up to you guys at Nest SoCal Group and see if there's anything specific people want to touch on. And again, I want to thank you guys for putting this on for your clients. You're going above and beyond. I give you guys a lot of kudos for that. So thank you.
I can ask you the questions directly, Shadi, from the chat. There was a specific question regarding the transition between Prop 13 and Prop 19. If a senior sold a property in September 2019, does the new purchase price limit of 5% within 1 year or 10% still apply?
Okay, so I just want to say, if there's a death that occurs before the Prop 19 date of February 16th, or a sale, they purchased or sold a property, and if they bought their new property, they should get their low property tax basis. I'm just going to answer it in that generic.
The question is, the property was sold before Prop 19 went into effect, and a new property has not been purchased yet. So when the new property is purchased, do the Prop 13 rules still apply or Prop 19 rules apply?
Well, if you purchase the property after February 16th, you're going to be in the world of Prop 19.
Yeah, but the original property was sold before Prop 19 went into effect.
So the sale doesn't affect anything. I mean, you might be asking, are you asking capital gains tax, or are you asking issues? Or are you asking when they purchase the new property, are they gonna get their same low tax basis?
Yeah, about the
They sh-
property tax basis transfer.
I would imagine it should apply. I don't really know, to be honest with you. I need to think that scenario through more. My understanding is the whole point of Prop 19 is that they can get their current low basis. I mean, I would imagine if it's within a certain time frame, they can carry over that low basis from that last purchase of the property in September.
Okay, thank you.
And there was another question as to whether or not, and you addressed this a little bit during your presentation, but if the property, let's say for instance, my parents have a family trust and their property is a very, very low tax basis from that they've carried forward from the 70s, just like your example, but the property is in trust. And if my parents pass and they give, I'm the heir for that property. If I don't move into that property just because it's in a trust, I'm not protected, correct or no?
If it's a revocable trust, you are not protected. The
Right.
trusts that are sort of protecting the tax basis from Prop 13 to Prop 19 are irrevocable trusts that we're putting in effect.
Right.
And so, and there's different types of irrevocable trusts, because when you transfer a property into an irrevocable trust, there are certain trusts that keep the step up in basis. There's some that do not. So that's a whole tax discussion that we have to have with the family to see what meets their needs best.
Yeah, I think a lot of people are used to having just a simple family trust. That's a
Yes.
revocable family trust, and
Yes.
that will not protect you against the increase in tax basis for Prop 19. If you
Very,
don't.
very good question. Correct. It does not. Please understand, revocable trusts protect you from probate, conservatorships, those types of things. Okay, it keeps your affairs private and keeps the courts out of it. So you could just divide the assets and distribute to the beneficiaries, you being the trustee, whoever the named trustee is. There are some huge benefits to revocable trusts, but what Prop 19 is doing is not something a revocable trust can protect.
Another question was, what if your properties are, what if the title is being held under the name of a corporation?
Again, that is a very good question, and you have to go through the analysis. So just to give you an idea, when someone calls me, I say to them, how was the properties purchased? The original purchaser, was it the LLC or was it the individual or husband and wife, and then it was transferred into the LLC? It's hard for me to make an analysis right here on the spot. You have to go through the process. Depending on the answer to that question, then the planning would be do this or do that. I mean, the benefits though under analysis currently is there is some more wiggle room for planning. Some people feel that there's still some wiggle room even after the Prop 19 effective date.
One of the questions, it's kind of a question that I already answered in the chat, but I know that there's some time periods in here. So let's say, for instance, that my parents, I'm just going to keep using myself as an example.
Sure.
My parents pass away and I'm not going to move into the property. At the time of death, that is going to trigger a reassessment of the property tax basis. How long do I have as the heir to sell the property without supplemental taxes being levied?
Well, here's the thing, and here's the thing, that from the date of death, those taxes are starting to accrue.
Right.
So there's not really a time, okay? So the assessor's office will basically say, oh, child acquired it at this time. Remember, you get some credit up to the million, right? So that if you sold it 3 months later or 4 months later, if it's 4 months, they could still tack on. If there's an increase, they can tack it on for those 4 months. It goes by date of death. Same as, so that works in the reverse too. Some people are panicked. A client of mine just lost her dad last week. Oh my God, Prop 19. Oh my goodness. And I said, look, it's date of dad's death. So that's pre-Prop 19. So we should be able to apply for that parent to child transfer, and that family would get that property tax credit. After Prop 19, there's not a time frame. It's not like the assessors like, we'll give you 6 months or a year before that property tax credit goes in. So at the time of sale, you'll notice a lot of times with realtors in escrow, they're getting those notices from the assessors like, hey, this is what's due.
Yeah, so that just for everybody's intents and purposes, for your awareness of it, from a real estate perspective, when we go into escrow, let's say, for instance, we're representing the heirs of the estate, whether it's a trust, whether it was through anything, through any other vehicle. If the heir is selling the property and we're in escrow, the title holders in the assessor's office are going to send a demand for any taxes due. And
Yeah.
that could include now a supplemental tax bill for the difference between what the original old property tax base was in the time of when that person acquired it upon the date of death of
Correct.
their parents. So
Yeah.
that supplemental tax bill is coming into play, or will be coming into play after April 16th. So just be aware, for all of us on the call that have parents where we know that we're going to be the heir, or for the parents that want to explain to their children who they're leaving their property to eventually, that's something that they should be aware of, is that there are going to be tax ramifications
Mhm.
potentially if they don't move in, and there's still exclusions that apply.
Correct. I will share one last sample too. I did do a bona fide purchase. So a sibling, one child purchased mom and dad's property from the revocable trust. I mean, money changed hands. There is a promissory note secured for a certain little bit, he paid like 700,000, but the trust carried a note for 100,000 because the property was worth 800K. We could do transactions like that, but as you can imagine, all that takes a lot, some time to put together. I think the challenging part is having these conversations where we're just going through the analysis, and we as attorneys have to go through the analysis pretty quickly to figure out, okay, what's the best option, and let's implement as quickly as we can.
Right. So from Ida, her question, and I think this is probably as far as what vehicle can you use right now prior to the February 11th date? And I know Logene's asking this too. Can you make a revocable trust irrevocable before February 11th?
No, it doesn't work like that. You literally have to create a separate irrevocable trust to transfer that property into the irrevocable trust. By the way, I just want to be clear because there was a question in the chat. You can have a revocable trust and an irrevocable trust. You can have some assets in your revocable, and you can literally just transfer, that one property into the irrevocable trust for purposes of Prop 19. But you cannot convert a revocable automatically for this purpose.
Got it. So it has to be a new irrevocable trust.
Yes. And that's just one option. So,
And that includes having the property recorded into the name of that trust by February 11th. So
yes.
that's why this is such a time sensitive issue that we wanted to make sure people were aware of. There's very little time to act.
Yes. I mean, this is just an example of one of the things we've created, and these are just the deeds for the trust. So it's quite a task.
From the chat too, what is the cost to move my property to a revocable or irrevocable trust? I'm sure that probably depends on the complexity of the trust.
Yes. I mean, you could have a $20 million property. There's a lot of other moving parts to it. I mean, generally speaking, in our firm, revocable trusts average between $3,000 and $4,000, but this is all in. We provide everything for the estate planning needs and ongoing services. So it's hard to just blurt out, fees. Irrevocable trust planning, in our firm, it starts at $8,500 and it goes up from there. I know a lot of practitioners are charging maybe into the 15, some can charge 15,000. There was one client that was in the 20s because, again, there's a lot of moving parts to that property, and it was a huge property of significant value. So, but there are other lower cost options, so don't hold me to my pricing.
I think we have a question.
Oh, okay. I wasn't sure you could hear me. I missed the first 10 minutes. What's to keep somebody from adding their children? I would be the parent here to the title, and then I pass away and leave everything alone. Don't take me off title. What's to keep somebody from doing that to eliminate the reassessment?
I'm so sorry, Michael. I don't quite understand your question. You're saying, are you asking
So
if parent can stay on deed?
I add one of my child or children to my rental. This is a rental situation. I add them to title, and then in 20 years I pass away, and right of survivorship, they inherit the property, but I'm not taking off title.
That example right there, all you did is, if it's just you and your child, and depending on what percentage, let's just say you did, you and your child, with as joint tenants, all you did there is transfer 50% of the property of the child. They get the property tax credit for 50%. But when you die 30 years from now, depending on the formula, 50% could get, reassessed. You get $1 million and you still get some credits. that's a formula that we have to talk to in more detail. But you can add a child as a joint tenant and then,
You
Try
can,
to
but it
say-
definitely triggers some other things that could potentially have tax implications. So if you do a quitclaim deed, a simple quitclaim deed to add your, your children onto title, you could be triggering other taxable events.
absolutely. And then now the question is, it's a rental property. How do you account for the
Who's going to
rent?
keep the rents? Yeah. Who's going to
Just
get credit
goes
for the
on-
rents?
Yeah. Trust me,
But
my
definitely
husband's
talk to your CPA and your tax advisors, because you could actually be, if you're planning on just continuing to maintain the rents for yourself and you're just putting your children on title in order to protect yourself from Prop 19, you could have a little bit of a nightmare on your hands in regard to filing taxes.
Yeah, not just that, but the assessor's office could say, well, this is not an actual outright gift too.
Right.
You have to be mindful of those things. There's so many aspects to this that I'll tell you, I hold my breath every time I'm putting one of these plans into effect, to be honest with you, because there's a lot of moving parts to it that we have to be mindful of.
Something that you just mentioned, Michael, though, that's a good point to note, is that in the Prop 19 world, after April 16th or April 11th, however you want to call the date, rental properties, there is no exclusion for, as far as like you obviously, if it's let's say it's a motel or an apartment building or whatever that your heirs are not going to move into, or it's not practical, or it's a commercial building, there's no way to get around that. They're going to be exposed to the reassessment at the higher property tax base. So
After February 16th.
after
yes.
February 16th. So there's no way
nothing's
to
done.
have somebody take possession of those. Those heirs will be subject to the increase in tax base.
If nothing is
Okay.
done.
Unless
planning-wise.
something is done in a vehicle that
Correct.
you find prior to February 16th. Otherwise, they'll be forced to
Gotcha.
sell the property. They can always still sell the property. In any
Sure.
of these situations, you can always sell
Mhm.
the property. The heirs are just going to be in a position that they need to know about that ahead of time.
Gotcha, thanks.
Lou, we just had another question in the chat. Does that affect assessment over $1 million? Is that credit for a primary residence for the
The
assessment over $1 million in value?
Primary residence, the children get up, yes, they get up to $1 million of credit. Rental properties, credits go completely away in Prop 19 world.
Is the million already set? We don't have to do anything for that?
For the primary residence, it's set,
Yeah.
There's nothing, yeah.
Oh, okay. What if a child, what if,
Don't
we have
forget, the
three
child has to
rental-
move into the property still.
Yeah, they still have
Yeah,
to move into the
actually, we were
It's
property.
two
thinking about-
prongs. Move in
Okay,
and
think
you get
about
the $1 million
doing that
credit.
anyway. We have 3 children, we have 3 rentals. What if, actually, one of them we were gonna move into anyway, what if he moved in, claimed residency, we gifted the property to him? And there you go. There'd be no reassessment.
But you'd
Hopefully.
already claimed that was a rental property and you were claiming rents on that prior to death. Let's say that that's the scenario, Shadi. What if it was, if it's been maintained as a rental property, are they even permitted to move into the property?
You
Again,
have to like what, February 11th to do that or 16? I mean, I'm going to defer not to answer that question just because I don't know. You would have to move in, make it your primary residence.
Yeah. It has to be your primary residence, Michael, in order for your children. So you couldn't have 3 separate primary residences. This is
I didn't quite understand it because he was like, I'm going to move in and then gift it to my child. So I don't.
And he's saying his child would just move, each of his respective children would just move into each of his respective rentals, but they've been being maintained as rentals. They're not his primary residence.
Correct.
You're
they would
gifting
be-
it to them at present time. All you get is $1 million in rental property credit. And then, and if you have a spouse, they get $1 million. This is probably a discussion better to be had outside of the Zoom.
Yeah, so why don't you put your contact information, Shadi, in the chat for everybody so that if we have some very specific scenarios, you can go into more detail outside of the Zoom. I do want to mention a couple of things that Shadi mentioned on the positive side of Prop 19. The positive being there is a lot more flexibility for seniors who are over 55 to now be able to sell the big house and downsize, or decide to move maybe to a more coastal location, a more, Palm Springsy location. Anywhere in California now, a senior can sell their property and they can purchase a property of equal or lesser, equal value, or equal or greater value, and be able to take their property tax base with them. And they can do it up to 3 times now, where the limitation used to be that you could only do it 1 time after the age of 55 and only in participating counties in California. So that really allows people to be able to make much more flexible decisions about what they're going to do with the equity that they take out of their current residence, if it's a big house, and where to move that equity and keep that low property tax base. Because a lot of seniors were locked in because they couldn't afford to buy something that wasn't at least equal or lesser value and live in a place that they wanted to live. Now they can live wherever they want in California and be able to keep a lower property tax base. But if you do buy equal or greater, there is some step up in basis. It's the difference of the what your old property tax base was between what you sell for and what you're purchasing at. That difference is the only thing that you would be potentially have some kind of a tax assessment in addition to your low tax base, but it's not the entire amount. So it definitely does give you a lot more flexibility over the age of 55, depending on whether or not you're staying in California. If you're not staying in California, you don't get the lower tax base.
I think they used that to sugarcoat what they really wanted was the Proposition 19 about
Yes.
reassessing.
That's
I
the
mean,
whole
was
reason it got
like,
passed.
was not- Look at all the people that don't own rentals. 19 is a great proposition for them to have. It's just all good news.
Right, but for rental properties and for parent to child transfers, that's where the real urgency comes from, and wanting to be able to communicate this to our clients, to our friends, to our family members, that this is a real issue that we're all facing now. For any of us that own property or own multiple properties, if we're going to pass these to our children or have property passed to us, we need to be aware of what the ramifications are.
And Shadi has to take off in a minute. We're a little bit over time, but we do plan to have another event. I'm Andrea Connor, by the way. I work with Manya Persekian here in Orange County, South Orange County, and Noelle, who's been speaking, is our team leader. Thank you, Shadi, so much. We're hoping to put another one together for
Thank you so much.
estate
Thank you guys
planning.
for having me.
This was also
Thank you.
recorded today, and for all the participants, we'll send a link of this recording back out to you. This was also streamed live on our Facebook page at Nest SoCal. So if you want to find the recording or watch that back, it'll be on our page, and you can share that with friends.
Perfect. Good luck,
And if-
everyone. Be safe out there. And Nest SoCal Group, thank you so much for having me today and for putting this on for your clients.
Thank you
Thank
again,
you.
Shadi.
We'll
Thank
send
you
you
all
all
for
an-
participating.
And we'll
All right.
send you all an email for our next event. Hopefully,
Okay.
Thanks.
Awesome. Bye, everyone.
take care.
Bye.
Bye.
Bye all.
Bye.
Thanks again.